One of the questions that comes up a lot with my clients, both in-network and out-of-network, the in-network providers who are getting fed up with being in-network, and the out-of-network providers curious about what the future looks like for out-of-network, ask, well, what does the future look like for out-of-network? Is it going away in a year or 2 years or 3 years? And we've had mixed reviews on whether that's the case. What I will tell you is that the statistics show that about 73% of most employees of any kind of an employer or a company have out-of-network benefits, and they predict that to be in the 80% range by the end of the year 2012. We see that that is actually a profit center for insurance companies or the TPAs, because what we find is that those who pursue out-of-network reimbursement get fed up at the first, second appeal level and then let it go. And so they end up taking whatever the insurance company is going to pay them. The interesting thing is the theory behind out-of-network versus in-network is this. If you're in-network, you get the reduced fee schedule, so you have to take that hit, but you get the increase in patient volume. So you are, let's say, taken care of on the backside because of the increased volume. Likewise, the theory for being out of network would be that if you are out of network, you don't get the benefit of being the recipient of the volume of patients. Therefore, your reimbursement ought to go up for a couple of reasons. One, the patient's paying a higher premium theoretically for those out-of-network benefits. And secondly, the insurance company is saying, by the way, to the member who has the out-of-network benefits, guess what? You are going to have a higher level of responsibility, a higher percentage of responsibility than you would if you were using your in-network benefits, because we, the insurance company, have a higher percentage of responsibility, a higher dollar responsibility. That's kind of the theory behind it. There are those in the world like Blue Cross, for instance, who say, forget it. We don't care what you say. We don't really even care what the plan says. What we tell you, the public, is that we are paying out-of-network less than in-network. Or we are going to pay out-of-network some percentage of Medicare, which I know thrills all of you. When we start talking percentage of Medicare, we have an issue. These are the required slides that SMA required me to include, that I have no financial interest. But generally, let's talk about kind of what we're looking at when I talk about payer disputes. Really, what is a payer? Let's break it down to its simplest form. We've got the insurance company, the Blue Crosses of the world, that's actually pure insurance. It's a fully insured plan. They are hired by a company to insure their members, for instance. Or we have a third-party administrator where Blue Cross may be in a different role. For instance, with my law firm, I work for Strasburger and Price. Our TPA, we're self-insured. Our TPA is Blue Cross Blue Shield of Texas, and we have retained them because of their expertise so that they will do the day-to-day processing of claims, evaluating claims, etc. Theoretically, the firm, my firm, our plan administrator still has the discretion and control, theoretically. The welfare benefits plan is the employer or self-insured itself, like my firm, for instance. Probably 80%, roughly 80%, a little more, a little less, depending on where you are, of the patients you see will be members or employees subject to a self-insured plan. So clearly, the lion's share, the vast lion's share of any patients you see will be employees of a company that is self-insured. And that's important because of this. And ERISA is an important piece to this puzzle and to this discussion. In my firm, we probably have 200 lawyers, and give or take on any given day. 198 of them, when they hear the term ERISA, gloss over, because it is a completely, it's a very complicated, complex federal statute, which in and of itself might read fairly straightforwardly, but over the past, I guess it's been 25, 30 more years, maybe 35 years actually, that it's been enacted, that there have been all kinds of regulations and case law and lawyers arguing, spending entire careers talking about ERISA. It really is just this. It's the Employment Retirement Income Security Act. It was enacted in 74, became effective in 75. It really governs employee benefit plans, including pensions, 401ks, those kinds of things, but it becomes relevant to what you all do because it governs healthcare benefit plans. And what it does is it says, as an employer in a self-insured situation, that you have to treat your employee in regard to their welfare benefit plans, including healthcare benefits, in certain ways. And the employee has certain rights as a result of the welfare benefit plan that they're a member of, and ERISA governs that. What it does is it establishes standards of conduct for plan fiduciaries, meaning the plan administrator, if it's a company, for instance, and it provides appropriate remedies and access to the federal courts. Again, these are all rights and remedies and things that are available to the member. It gets to you in this way. When you see a patient, first time comes to your office as a provider, the patient fills out a registration form. And one of the things the patient does is assign their rights to reimbursement to you. So that's how ERISA gets to you. If they have appropriately assigned the rights that they have to you as the provider, then you, assuming the assignment's good, and we're going to talk about that in a little bit, assuming the assignment's good, then you have the same rights that the employee would have to pursue ERISA claims if the TPA or the employer plan has treated you as the patient inappropriately. Now, one of the things I say here is we've got the insurance company, the TPA, and the welfare benefits plan. The TPA, in the situation where Blue Cross, for instance, is processing my firm's claims for its employees, theoretically doesn't have discretion or control. It's typically the employer that does. Well, in reality, what happens is, for instance, my firm's situation, our plan administrator, my guess is, does not really understand what's going on day to day with individual claims. So there are arguments in the courts whether actually the TPA exercises discretion and control of Blue Cross when processing the claims. And so if you ever get into a litigation context with the employer and the TPA, it might actually be the TPA that exercised the discretion and control or determined that the benefits weren't paid to you standing in the shoes of the insured, of the patient. Just kind of through the basics, what happens with the patient? They seek services from you, the provider. Determine whether they have in-network or out-of-network benefits. The assignment comes into play. Let's make sure your assignment is in order so that when you see the patient, they sign the registration form, they fill out the assignment, you have all of the rights that the patient has. You want to make sure that the patient assigns you everything they have so that you're not stopped at some level along the way from pursuing the claims against the TPA or the employer. Copay, co-insurance responsibility. That's another big issue. I have clients constantly asking me, typically out-of-network clients, who say, what can I do with the copay? The out-of-network copay is really big. And if I collect that full copayment from my patient, well then he's going to go somewhere else. Any of you ever had that situation? Okay, that's good. Has anybody ever come across a situation where they say, I want to reduce or waive the copay? Anybody ever seen that? What's that? Does anybody ever reduce copay based on the individual circumstances of a patient that's documented? There's one, there's another. Okay, that's an important topic because this is an area right here, actually with in-network and out-of-network. It's less common in an in-network situation because the copay is smaller. It's more common in an out-of-network situation because the copay is bigger. And then you have the CMS issues, which you can't waive copay. Generally speaking, there are some exceptions. We'll talk about that. But that's one of the areas where the private payers, by the way, are coming down very hard on providers and ferreting out whether the patients are actually required to pay their copay or something reduced from what the copay is supposed to be according to the plan. And every time I talk to you in terms of according to the plan, what is this plan? We hear the term the plan constantly, and we take what the insurance company or the TPA tells us and just assume it's true about the plan. Well, in reality, what we see is with some of the big private payers, they refer to the plan commonly, but you may see 100 different patients, and the insurance company, Blue Cross, is talking to you about the plan of those 100 different patients on any given day. Do you think they've actually looked at the specific plan? One thing you can do as the provider, assuming you have an appropriate assignment that gives you all the rights of the patient, is to ask to see that plan language. And many times the plan language doesn't address the issues they're saying that it does. And then you have an area of vulnerability there that you can press on to get them to give you more information, come to the table and negotiate with you. Assignment of benefits. I've kind of just put generally up here. Bad example, Judge Gray opinion, good example. Bad example. A bad example of an assignment of benefits is one where it says a line or two about I, the patient, assign my rights to reimbursement from the insurance company to Dr. Smith, and then signs his name. That's a bad example of an assignment. Why is that? Because certain courts, including Judge Gray Miller in the Southern District of Texas, say that is not, the patient is not assigning all of his rights to you. He's assigned you the rights to reimbursement directly from the insurance company. And if you're happy with the reimbursement provider that you've gotten from the insurance company, then excellent. Then the assignment did all it needed to do. If you're not happy with the reimbursement you got from the insurance company based upon that assignment, then some courts, Judge Gray Miller in Houston, federal district court judge, would say, tough, you don't have any rights to pursue ERISA, or breach of fiduciary duty claim any further. Do any of you have assignments in your practices that essentially say you get right to reimbursement and nothing further? Do any of you have those kinds of assignments? Are any of you not? Yes, sir? Yeah, that was my next question. Do any of you know, as we sit here today, what your assignments look like? You do. Very good. 1 out of 40. I'm not surprised because really what happens is your office staff takes care of that. One of the things I would suggest is that you look at these because we've had a recent issue with this problem. And I'm going to go down a little further in this talk and tell you why it really matters. But to start with, the assignment, according to Judge Gray Miller in Houston, I said Judge Gray, it's actually Judge Miller. He has two first names. I get confused with him. Judge Miller in Houston said, if you don't have specific language that says, I, the patient, assign all of my rights, and that includes to appeal, to pursue litigation, to pursue breach of fiduciary duty claims on my behalf, then that court says you don't have standing as a provider to bring these breach of fiduciary duty claims. You have to use that exact language. Now, I will tell you that seems to be a minority opinion in our city, within our district, but it was good enough to get that case for another provider kicked out. You don't want to be in that situation. You want to have all of the language you need in your assignment so that you can pursue ERISA claims against the payer, because that's where the meat of it is for you, because ERISA gives you, the provider, lots of rights and puts some meat on the bones for you when you want to pursue the payer when you've been treated poorly with your reimbursement. What happens is they argue, the court says you don't have standing because your assignment is insufficient to pursue these claims because it doesn't include the exact language. There's also a judge in the Eastern District of Louisiana who feels the same as Judge Miller. The courts across the country are kind of all over the place on it. The Fifth Circuit, which Texas and Louisiana are in, tends to say assignment, if it gives the rights to reimbursement, is good. Tends to say that. Two judges, Eastern District of Louisiana, Southern District of Texas, disagree. Copay. Generally, the comment, and I raised it with you, is you can't waive it. I mean, I think we all know you can't waive a copay. I hope we know that. There are some situations where you can vary the copay if you have specific circumstances. Texas statute says specifically you can't do it. CMS Medicare, obviously you can't do it. generally speaking, in plan language. What happens is the plan that these insurance companies refer you to, which we never see, typically say if you, the provider, do not collect the copay from from the patient, then we, the insurance company, don't have to pay what we owe. Because when you submit that claim for reimbursement, let's say you're out of network, you submit that claim for reimbursement and you list full billed charges, you're representing to us that you've collected the full copay from the insured. And if you haven't, then that's a misrepresentation or fraud, and therefore we don't owe you what we would typically have to owe you. We owe you nothing. We have some insurance companies in Houston filing lawsuits against providers for a scheme of fraudulent waiving of copays. That's kind of how they're framing it. They're getting aggressive on this, so you don't want to do that. Now, what can you do? You got a patient that comes in and says, I can't afford to pay the copay. Okay, well, that's okay. You can consider the individual financial circumstances of any given patient and document that and reduce or waive to the extent that you believe sincerely that there's a problem with that. What you ought to have is a policy on board that specifically addresses it. The OIG, or the Office of Inspector General, has given guidance on that, extensive guidance on that. If you have a policy that's compliant with what the OIG says, which you can find online, it's good to have that on board. And then when you consider the individual circumstances of a patient, you can reduce or waive the copay if it merits it. What you need to do, though, is you have some providers out there who are just waiving it across the board or giving a prompt pay discount. You don't want to do that either, because that's a kind of across-the-board discount. What you want to do is if you're going to have patients who cannot afford their copays, you need to have peaks and valleys, not some uniform across-the-board kind of copay waiver. Does that make sense? Sounds to me like many of you may not have that problem to begin with. Is that fair? Anybody have a problem with that? No? Okay. What's that?
Especially if you're on a network and they pay a big copay to begin with, we have to recheck them the next day, and we have them come back in. It's hard to charge them that second copay.
Right.
You know, especially if we know that they can't afford it.
Right. In that situation, and you're talking about out of network, and the plan requires that you collect the second copay because it's the second episode of care or whatever, that's the kind of situation, I think, that if you have a policy on board that specifically addresses situations where the patient literally is indigent, and let me tell you, the OIG defines indigency as literal financial indigency, financially unable to pay, or medically indigent, which means because of my ongoing medical costs, if I continue to have to pay X dollars for this care over the course of 6 months, then I will be unable to pay my medical bills, or it will make it difficult for me. So the OIG recognizes situations like that, and the key is to have a policy on board that addresses those kinds of situations. Have the patient, when they say to you, I can't afford to pay that second copay, it's going to put me in a bind, to request that you reduce their copay, do it in writing, have it in the chart, and collect whatever they can pay. That will protect you, generally speaking. What you can't do is just say, okay, we won't collect the copay, or have your front person who has the first contact with the patient say, oh, we don't collect copays here, wink, wink, no problem, come on in. Because that's seen as an inducement to get that patient to come to your office versus your competitor down the street. You can't engage in that kind of practice. Yes, sir. There's not, but what you got to do is, you can do it one of two ways. You got to talk to the patient and understand that they have inability to pay that copay, and probably do a little bit of digging and have them specifically request that the copay be reduced or waived. Have them request it in writing. Have a form on board. It can be short, but a form on board that says I'm requesting it, and give options for why they're requesting it. Have them sign it and put it in the file. Well, if there's a couple of ways, to address that. One is you don't know they can't afford it, so you send them a bill for it, for instance, or you collect a copay up front and they can't pay the remainder or some portion of the copay, and you try to collect it from them, and then at some point they stop paying or are unable to pay, and then you write it off as a business decision. What you can't do, and what we've seen a lot of people do in the healthcare community and what the OIG and the U.S. Attorney doesn't like, is when you have a uniform policy of not collecting $1 from your patient, sending 3 collection letters and stopping. Because then it's really a ruse. You're not really trying to collect it. Your intent at the front end was to not collect it, and you're doing it for a lot of different patients. That's what you don't want to do. You've done that? Yeah. You don't want to do that. What you want to do is have a policy on board that addresses the situations where you would reduce or waive copay. You want to have a written request by your patient that says, I want, like I said, I need my copay reduced or waived for these reasons, and put that in the file. And it shouldn't look like every other patient situation, because so that you can show that you're actually considering the circumstances of this patient. Yes, Sonia. No. No, let me tell you, I have one client that this is interesting. Because first of all, when you've submitted the bill, it depends. Let me back up a minute. Are you waiving it up front based on what the patient has told you that they can't pay the copay? It depends. If you're just waiving copays across the board of patients, then the payer is going to find out that you're doing it because they're out there doing it, and your intent is wrong. If it's an individual patient who can't afford it, you've documented it, etc., then the answer is no. That's my answer. But Cigna and others are actually out there sending surveys to patients, asking them what they've paid, if anything. And then they come back to my clients and say, by the way, we've audited you over the past 6 months. We have the following sample of 20 surveys where the patient said, you've paid nothing, therefore pay us $1 million. We've overpaid you. You have to pay us back, etc., when you get into a negotiation stage. You don't want that to happen. But my guess is you all don't really have that problem. What you have is an individual circumstance where the patient couldn't pay it, described it for you, you documented it, you're good. Generally speaking, the OIG supports that, yes. Well, I spend quite a bit of time in training my clients, frankly, with forms and documents, et cetera. What you got to do is have a policy on board. And I know, well, what's the policy look like? So that's a good question. Have a policy on board that follows what the OIG says. I can follow up with you after this, or any of you, and give you what we think is the sample policy. Or you can go on the OIG website and search for this issue, and it gives you all the language it should include. Then you need to have a form that kind of tracks that shorter form that a client can read, a patient can read, requesting why they're getting the copay waiver, and sign off on that. You can actually have the options in a box. This should not be a regular occurrence with your patients. This should be a few off here and there based on their financial circumstances. And then you can reduce it or waive it or have them make payments over time, something reasonable. Yes? Really? Yeah.
Huge number of our visits are preventive care, annual exams, etc. And it seems as if the insurance companies are doing a very poor job of letting their own patients know whether they're in a grandfathered plan and or if they're not. Mm-hmm. That's first of all. So we're having a hard time figuring out who doesn't pay copay and who does.
Right.
And then since we normally collect copays up front, if the patient comes, the confusion also becomes if the patient comes in for a preventive care visit, then also, oh, by the way, doctor, I have this problem, X, Y, Z. And then it becomes a preventive care visit plus, level 2 or level 3 code
right.
for the problem. Collecting the copay on that actually, because then technically
right.
it's not just a preventive care service.
Right. So you've got one visit. It's a complex visit. You're doing 2 different things, and it would technically require 2 different copays. That's a very good practical question. I think that would probably, I would ask the insurance company if you can get a warm body before you engage in that. Otherwise, you might. Does that happen a bunch? It does. That's a real life problem.
patients not even knowing and their insurance information, unless we're on a live feed with
Right.
their company,
Right.
knowing whether or not they need to pay a copay and whether our staff, there's a little bit of a confusion there.
I might, I don't know the answer to that question. My practical solution would be something like, if that comes up regularly, I would talk with one of the payers and ask them about that situation. My guess is they're going to say collect 2 copays, which may be impractical. Right.
It's like a copay after the fact, because a lot of times, as Jeff's pointing out, that issue comes up during the preventive medicine,
Right.
or the preventive care visit, and so they're getting billed after the fact, and suddenly they get notice that they owe a copay,
Right.
and they're usually irate because that was a free visit. They don't understand.
Right.
We were having a problem with that in my office too, because they all, the ones that don't have a copay, and then like you said, a sick patient and a preventative care. So, after a few fights that patients had with some staff in my office and a few bills that they were angry about, I made them start telling them all, you might have a copay,
That's
blah,
good,
blah,
yeah.
blah,
Yeah.
when they came in, because
that's a really
first
good
of all, we were losing the copays because we collected them at the front instead of at the end.
Right.
Then they're getting bills and
Right.
then fights are breaking out.
Right.
We go, if you have a problem with it, check with your insurance company.
I think that's probably, that's
Come
a,
up front and tell them all,
Yeah, that's
if
a
you
good
bring
idea.
up something besides a health check,
Yeah,
you're
good
gonna
idea.
be,
I think that's a good, it's probably going to turn the patient off.
When
It's
does
gonna
the
solve-
grandfather thing end?
That's I don't know the answer to that. I can get that answer for you. I don't know.
Rates go up.
Right.
14 was, right?
Yeah, probably 2014, but I'll check on that. Yes, sir.
Can you help us ameliorate any risk associated with practicing professional courtesy by not charging our peers?
Right. That's a good question. That's historically been what doctors do, right? Children of doctors, friends, etc. I've never had that question asked, and it's a great one. I don't know the answer to that, but have you ever had that challenged?
Well, what we do is an unwritten policy. If they have a copayment, we'll collect the copayment. We'll submit the claim to the insurance companies. But if the insurance company doesn't pay, they have a high deductible. We never send a bill for the whatever the other balance would be.
Right.
But that's not written down anywhere.
Right. So you would collect the copay, but not.
If there's a copay, everybody pays the copay.
But then you wouldn't submit you would submit to the insurance company.
No, I do.
Okay.
But then if it comes back that the remaining balance is for the patient to pay.
That's after the EOB comes and you understand what their portion is.
Right.
I think again, I'm not sure he's a friend, he's another physician works, but document what you've done, that we've waived it, I guess. And what you would probably say is, you can't say it's a financial situation. I don't think it's really an issue because those situations are so few, and one, and two, it's not the fraud that they're trying to ferret out. So I'm not saying it's right, but I don't think it's a focus. And so I think I would not change the practice you currently have unless you just want to. Best practice, let me stand up here right now and tell you, best practice is to collect full copay, collect full amounts from the patient that's owed by the patient. That's your best practice. But I know in reality that doesn't happen all the time. This is one of those situations. I think that's a low risk area. Because remember, the goal here is to, across the board, lower from the payers and CMS is to lower the cost of healthcare, to ferret out fraud, to try to prevent inducements from getting patients to you rather than your competitor down the street. That's not risky for that, right? So again, I'm not saying that it wouldn't be attacked on a one-off basis here and there. I think it's low risk. In my business, we talk about risk, and that's low risk. I have to move on a little bit here. We're moving right along in time. What is a dispute? What kicks in your rights to pursue the ERISA claims? Well, denial. What's considered an adverse benefit determination, which kicks in your rights under an ERISA plan? A denial, a flat-out denial, an underpayment, or a request for recoupment. Anybody gotten a request for recoupment? Ever seen one of those? One back there. Okay. Y'all are good. Y'all are doing everything just right. Well, any of these three things right here, including the request for recoupment, which is based on some kind of audit where they've determined they've overpaid you because you did something wrong, all of these give you appeal rights under ERISA, which means that you have at least 180 days from the time of that determination to pursue your rights because you now have the rights that the insured gave you if you have that good assignment under ERISA. And by the way, an adverse benefit determination, underpayment, is anything less than billed charges. So if you're out of network, for instance, and they pay you anything less than billed charges, which is always, and that's considered an adverse benefit determination. Now, what ERISA also says is when they notify you of what they've paid and what the reason for it is, they have to tell you these things, and they almost never do, which is what's interesting. ERISA says you have to give the specific reasons for the adverse determination, specific reasons why they paid you at the level they paid you. A reference to the specific plan provision being relied on, which they never do. The plan, remember, each patient is a member typically of a different plan. So you have to be referred to the provision of the plan for the employer that this patient was an employee of. You see that on your EOBs? Typically not. Any information the claimant needs to provide to complete the claim and an explanation as to why that information is required. Rarely see that either. Sometimes it comes in the form of requests for additional medical records. A description of the plan's review procedures and time limits. Again, you have at least 180 days. No plan that is governed by ERISA that's self-funded can give you less than 180 days. They can give you more, usually don't, but they have to give you at least 180. So you know you have 180 days. And then the appeal timelines. They can only make you go through 2 levels of appeal. And at the end, a statement that the claimant is entitled to bring suit in federal court after exhausting the internal process. Now, that's not really where you want to be, but that is the ultimate court of justice if you can't resolve it short of that. Typical EOBs that I see a lot of are like Blue Cross, for instance. They never, the ones I've seen, rarely identify the employer of the insured. It's important that your registration form, and we see a lot of this problem, include the name of the employer of the insured, not of the patient, because it can be different, of the insured. And why is that? Because if you have the name of the employer of the insured, and it's a self-insured product, a self-insured employer benefit plan, then you have an additional person or entity to go to if you're unhappy with the claims process or reimbursement. So you have Blue Cross Blue Shield, the TPA. Now you have Cisco Corporation or Ford Motor Company or Microsoft or whomever. You can also go to or CC your complaint to Blue Cross about the claim. And we found that's been very helpful in getting the insurance company or the TPA to negotiate with you about your reimbursement. Because in the TPA employer situation, the employer is their client. My firm is the client of Blue Cross Blue Shield, for instance. And if you can copy the plan administrator at the employer on your appeal, you often get the attention of the Blue Crosses of the world, and they come to the table and negotiate more fairly with you. That's what we've seen. UHC, for instance, I have a client with a EOB that recently came back stating this. The plan does not provide reimbursement for amounts billed by the provider that the patient is not required to pay. We understand that this provider or physician waives coinsurance and or deductible amounts and may accept the benefit payments paid to you as payment in full. And what that meant was no reimbursement by United Healthcare to that client. Quality of claim file. One of the things you want to look at from your perspective as a provider from the beginning is make sure that your own file on each particular patient is in good order. Consider statute of limitations. We'll go through that in a minute. Make sure your appeals are timely made per the plan procedures. And if they don't give that to you, ask for it. And that your file contains necessary and complete documentation. If you actually have the handout of my PowerPoint, there's a misstatement on this slide. I've corrected it here. There is a 2-year negligent misrepresentation statute of limitations in Texas. I don't know about elsewhere. And so if you are going to say, for instance, well, yes, I understand what you're telling me, this was not covered, but when I called you a month ago and asked if there was coverage for this procedure, for this insured, you said there was. You might have a negligent misrepresentation claim even if there isn't coverage because you relied on what they told you and did the procedure accordingly. I know they have all that caveat language, but if you have a cause of action in that area, it'd be this. negligent misrepresentation. You have 2 years from the date the representation is made. If you are actually in contract, in network, and you have a dispute with the payer in Texas, and I think most places, but I only speak on Texas and California because those are the only 2 places I'm licensed, 4 years. And then if you have a breach of fiduciary duty or ERISA claim, which what I'm telling you, most of your claims should fall into this category, it's 3 years, but it can go up to 6 years depending. But think of it in terms of 3 years. 3 years from the date of the adverse benefit determination is when you want to consider your statute of limitations to run. So keep that in mind. Make sure those of you who outsource billing, that those folks keep these dates and statute of limitations in mind. It's important because after the 2 years, the 4 years, or the 3 to 6 years, then you're barred from bringing the claims. Appeals timely made. One of the things you want to ask for in your appeal is a copy of the plan or the summary plan description, which is the smaller document for the employee that describes what coverage he has. Press them on that. Ask them for it. Require them to produce it to you. If they don't, and you requested it within, day 31 and after of your request, they're charged $110 per day penalty for failure to give it to you. The EOB should explain, although it rarely does, and you have at least 180 days, as I said, to appeal. What you want to ask for in the appeal, again, the plan, the summary plan description, and identify the plan administrator. That'll correct your registration form if you didn't collect that information from your patient. You want to know the employer of the insured and make sure that blank is filled out. If you don't get it there, you can ask for it here, but you'd rather have it there because then when you send the appeal to the insurance company, you can CC the employer or the plan administrator of the employer when you make that appeal, and you've got 2 people working for you. Patient file should be complete. These are the things we like to see for quality control purposes. Patient registration, identify of employer of insured. Disclosure of financial interest. To the extent you're a physician who has an interest in a facility to which you refer patients, some of you may, we have several clients who do in Texas, then you have to reveal at time of initial contact and at time of referral, and those could be 2 different times, and you got to do it 2 different times in Texas, that you have a financial interest in a facility to which you might refer this patient. So you got to do it twice in Texas. And it's also just under the state law. It's also considered by the Texas Medical Board unprofessional and dishonorable conduct if you do not reveal the financial interest in a facility to which you might refer patients. What does that mean? If somebody reports you, like an insurance company, which they like to do, then they'll undertake an investigation, which you don't want to happen. I don't know if the other states, Arkansas and Illinois and Kentucky and Alabama and Virginia, I don't know what your state boards do, but it's probably worth looking at the rules and regs. Make sure that you have the insurance information, including employer of the insured, assignment of benefits, and designation of authorized representative. Make sure the patient gives you all of their rights so that when you go to pursue your appeals, you have all of their rights and the court can't say you have no standing. Make sure that the patient medical record is thoroughly documents the care that's provided. That seems like an easy one, but more often than not, it's not. Justifies medical necessity for care, and that you have dated, timed, and signed progress notes. Doctors, you don't like to do that. Claims forms, EOBs, appeals documentation, and then thorough documentation for the reasons for collecting less than the full copay, which we've discussed. When you're appealing an adverse benefit determination, using your rights that you now have under ERISA through the assignment, you want to make sure that this particular event you're appealing does not evidence some sort of systemic overbilling, billing for services not done, allegations of fraud. If you have some concern about a particular claim that you're looking at that you're going to appeal, you might want to say, you know what, this looks like we have a problem. Let's make sure we don't have this problem in a systemic way, and let's not appeal this one, for instance, because we don't want to highlight ourselves. We want to correct the problem. You also want to know what makes this payer tick. Blue Cross, for instance, as a matter of course, pays out-of-network less than in-network, just as a general rule, and they like to force to litigation. We've seen a little less of that with this kind of pushing on the employer of the insured and copying the employer on the appeals letters. We've seen Blue Cross get a little weak-kneed. And how to engage the payer. We often send a demand letter along with the appeal outlining what ERISA rights we have and what they are required to give us under ERISA, which they're often shocked that the provider even knows what ERISA is. Attach a proposed lawsuit. That's one tactic that might be too aggressive. Telephone conferences, negotiation with in-house counsel. We do that a lot. And then develop a rapport with in-house counsel, which fortunately or unfortunately, I've developed that kind of rapport with several of the big payers. False Claims Act. This conversation about reimbursement cannot be divorced from considering what can happen on the back end, and that is the ramifications under the False Claims Act. The False Claims Act is something that can get you as a provider in trouble without you intending to get yourself in trouble, without you intending to do something that runs afoul of the law. It can just happen. Its history, it was known as the Lincoln Law because it became, it was passed during the Civil War to combat profiteering by those bad Union Army suppliers. It was amended in 1986 for modern day use, and that's the False Claims Act we know and love. Healthcare is a big area of pursuit by the U.S. Attorney and the government because of the perceived and I suppose actual fraud and abuse within the healthcare system. I know in Houston, the U.S. Attorney there is a large part of his time is spent evaluating whistleblower cases and determining whether he in fact is going to intervene into what's called QTAM whistleblower lawsuits, see if they're going to put the full resources of the federal government behind claims that whistleblowers have brought to their attention. As you can see, Medicare and Medicaid provide health care coverage for millions of Americans at a cost of $600 billion. I think it's more than that now. And one very current purpose of the FCA is to counteract healthcare fraud, obviously. What it requires, and this is important, to prove a False Claims Act case, any person who knowingly presents or causes to be presented to an officer or employee of the United States government a false or fraudulent claim for payment or approval. So knowingly billing for something that you didn't do, knowingly billing twice for the same procedure, etc. Any person who knowingly makes, uses, or causes to be made or used a false record or statement to conceal or void property to the government is liable, and this is the important thing, is liable to the United States government for a civil penalty of not less than $5,500 and not more than $11,000. That's per claim, plus 3 times the amount of damages which the government sustains because of the act of that person. Typically what happens is the government will see, or a whistleblower will be, let's say the CEO of a hospital and a major hospital corporation will have been there for a couple of years, and he's probably disgruntled for some reason and also has seen all kinds of what he calls thinks is Medicare fraud, billing for things that weren't done, for instance. And he blows the whistle. And then he tells the U.S. government and they investigate it. Well, let's say there's 1,000 claims or 2,000 claims or whatever it is. It's $5,500 to $11,000 per claim, plus the actual amount of reimbursement received through those fraudulent claims as the penalty, as the damages, excuse me. Now, there's an exception. If the court finds that the person who committed the violation furnished all information known to such person about the violation within 30 days, that the person fully cooperates with the investigation, there's no other criminal prosecution, etc., and that the person had no actual knowledge, then the court may assess not less than 2 times the amount of damages, and the person may also be liable for the cost of civil action brought to recover any of the penalty or damages. So they give you a big break. It's not a per claim penalty, but now it's just 2 times the amount of reimbursement. This is probably the most important slide because I said knowingly, but remember I said you don't have to have intent. I mean, you can knowingly let something pass you didn't intend to do it. That's one sort of passive way to knowingly do something. You could be in deliberate ignorance of the truth or the falsity of the information, meaning you think something's going on over here, but what you don't know won't hurt you. You turn a blind eye. Or you can act in reckless disregard of the truth or falsity of the information, meaning it's going on in your system, And you may not know it, you may not even suspect it, but maybe it's your duty to find it out. You have a compliance officer whose role it is to determine those things, and you haven't quoted that person with the appropriate authority, and it's rampant everywhere, and you should know it, for instance. So the important thing is no proof of specific intent to defraud is required. And some very good people get caught up in this because of that knowing definition. Stakes are high. Treble damages plus civil penalties for each violation. The FCA can be the part of a coordinated parallel investigation, criminal risk, loss of Medicare eligibility. And one of the things you do when you're representing a provider who gets caught up in this is you get a written letter from the U.S. attorney that says, okay, we're going to resolve this with you, or we're going to give you a declaration to help in your investigation of the other provider, but I want this written letter saying that my client is not is immune from criminal prosecution, that there is no way that in the future that the federal government is going to bring a criminal case against my client. And that happens regularly, and they're willing to do that in many circumstances. Recent example, in Houston, there was an imaging center where several doctors, like 15 to 18 doctors, were medical directors of the imaging center being paid $3,000 to $5,000 a month for quality assurance, all written contracts, and none of those medical directors knew that the other medical directors had those same contracts. And it turns out that the U.S. attorney is pursuing the imaging center in a False Claims Act case, and not criminally, but civilly in the False Claims Act case. A whistleblower blew the whistle, the lawsuit was filed, now the government's trying to decide whether to intervene. And so he's now talking to all the medical directors and trying to get testimony and information from them with some assurances that they won't be prosecuted criminally if they'll cooperate and give declarations, for instance. That's a typical example. Another example of a False Claims Act case is a former CEO of a hospital within a very large hospital system in this country determined that through his work there that doctors, neurosurgeons were paid $2,000 a day to cover an ER. Well, as it turns out, those neurosurgeons did not do surgeries or any kind of procedure or consultation that came through the ER. What happened was the level above the hospital at the corporate side was paying those doctors and dictated that deal with them in order to get their expensive, highly reimbursed, scheduled back surgeries to be done at that hospital. And so the theory was that they're paying for referrals, essentially, which is a big no-no, as we all know. And a False Claims Act case came out of that. The theory there is that what's the false claim? We've got payment for referrals, but we don't know exactly what the referrals were because you're not referring us to any specific Medicare claim that was made. And the point is that, well, when the claims were made, or excuse me, annually when you do your cost reports, you certify that you're following all the laws of the United States, including Stark and anti-kickback. And in fact, you weren't because you were paying for referrals. Therefore, it paints all of the claims in that given year that you made as a result of those physicians' scheduled, highly reimbursed surgeries at your hospital. Therefore, you owe 3 times all of those reimbursements, plus a per claim penalty of between $5,000 and $11,000. Common traps, lack of medical necessity, unbundling, false certification, which is the example I just gave you. When the cost reports you to Medicare certify that you're in compliance with all of the Medicare CMS rules and regs and laws, and when in fact you're out there engaging in payment for referrals, then it taints everything. Redlining, upcoding, kickbacks, obviously. Services not rendered, duplication of billing, billing for patients not eligible to receive a benefit, for instance. Those are some common traps. Some of these things can happen very innocently, by the way, and can be mistakes. And I will say, you can be successful, as unforgiving as CMS is, you can be successful in convincing them that it was literally a clerical or simple mistake rather than actual reckless disregard or other knowing violations. And if you do that and you have a good contact, for instance, within Trailblazer as an example, then you can sometimes get yourself out of what was an innocent situation. Yes? Redlining is, generally speaking, it is failure to treat groups of people based upon inability to pay or race or things of that nature. Just kind of wholesale refusal to treat certain groups for whatever reason. I just gave you examples, inability to pay, race, that kind of thing. Lower socioeconomic, something of that nature. Ignorance is not a defense anymore, obviously. Complexity or ambiguity of the Medicare rules. Clearly, they're complex and they're ambiguous and they're difficult to understand, even for lawyers. That by itself will not be a defense. Erroneous advice from a fiscal intermediary or carrier is not a defense. The same hospital corporation that I told you about, where they were paying for referrals, for instance, they had advice from outside counsel regarding whether there was a violation, and it was kind of a mixed bag, and they had a partial defense to it, and the hospital corporation actually revealed all their attorney-client correspondence and said, we asked a lawyer, and the lawyer told us this, we relied on his advice. And that relying on the advice of outside consultants can reduce, but it will not necessarily completely eradicate your liability. The key tam plaintiff, the whistleblower, for instance, who brings this lawsuit, initially, they will recover 15 to 25% if the government does intervene. If the government decides not to intervene and they are successful or settle, they can recover 25 to 30% as their fee, including attorney's fees and costs. There's a very detailed statutory structure about how you as the employer cannot retaliate against the employee for whistleblowing, which is probably obvious. There's great ramifications to that. Who are the whistleblowers? They are employees, the former CEO of the hospital. They are nurses. They are techs. They are physicians. These people keep us all in check. So know that they are the people who you work with, who are around you every day. Computation of damages, amount paid on a claim, less what would have been paid anyway. So if it was an appropriate claim, what's that dollar amount? Subtract that from what was actually paid. This is a good example. A case where physical therapy, there was an abuse of use of physical therapy. What ended up happening was the court awarded the minimum fine because otherwise it would have been too large for the provider to handle. The court has discretion to do that. How do you prevent? Understand the risk. Stay tuned to CMS updates, rules, regulations, and law. You can do that online. You probably all do that now. Regular internal audits to confirm compliance with new CMS. Review specialty updates, like your specific area of practice. Document well, including orders, dictated physician summaries, description of condition or history which makes the medical necessity clear. I can't emphasize that enough. And develop a compliance program. Larger providers have a compliance program without question. In the year of PPAC, in the era of PPAC and healthcare reform, you are going to be required to have a formal compliance program on board. Carefully choose your billing personnel. Make sure they're sophisticated and understand all of these issues. Supervise and consult attorneys when necessary, knowledgeable about the issues. Takeaways: if it feels wrong, it probably is. Common sense. Encourage open discussion by employees, which you should do with your in-house compliance officer. That person should be somebody cloaked with enough authority and respect that employees feel confident enough to go talk to that person. Intent to defraud is not required, and you must appropriately supervise the people you work with. Fight for reimbursement, do you, and understand ERISA. Have your assignment and financial policies in order. Appeal timely. Request the plan documents and summary plan description. You have that right through your assignment to request that from the payer. Ask for those documents so you can draw them to the area of the plan or the plan description, which they say they're relying on when they are underpaying you. Have a litigation strategy or policy in place in case you want to pursue litigation. Pick your battles and understand the False Claims Act risks, because that is the future of pursuing healthcare fraud is the False Claims Act in the next few years. Yes, ma'am.
This comes up more often than it should, where the patient themselves call their whatever insurance company that they have, and if we say that it's not a covered it's not a covered service that we can bill for, they will call their insurance company and they'll tell them that it is. And then we call back and we talk to a supervisor and they say, absolutely not. I need the name of the person that they talk to. But the patient is then very upset with you because they think that you're just not wanting to render a covered service for them.
Right.
And for their insurance to pay for it. And that comes up more often than it should. Is there anything that we can
That's
do?
interesting. And it's left hand, right hand is the problem because the insurance companies are huge, of course. And you have to go on what you're told, obviously. And then I guess what you can do is you and the patient get on the line and talk to the person on the speakerphone or something. That would be the practical solution. I've never heard that actually happening. But I would, you have to rely on what you've been told, is obviously, because you don't know what the patient's agenda or motivation is. They may have not been told that, but they just want to have the service, for instance, right? So I guess you have to assess the credibility of your patient as well. Louisiana's totally different. I mean, yes, sir.
On that neurosurgery example you gave,
Yes.
was the issue that they were being paid to cover an emergency room and they weren't?
Yes.
Or was the fair market value of the services rendered?
No
Like if they were
fair
being paid $100, would it still been a problem?
Well, fair market value came out because what they're saying is, well, we're paying them what the hospital down the street's paying them. And then the other side said, well, yes, but down the street, they're actually providing services through the ER. They weren't doing anything through the ER. So they were being paid for referrals. That was a classic pay for referrals. It was a false certification case because they had signed, the cost reports or whatever their annual report to CMS is saying we're in compliance with all the laws and statutes of the United States. Yes.
Is there a statute of limitations on false claims? And second, with all these consolidations, who's ultimately responsible for the false claims that happened in a practice before it was acquired by another practice? The person who was the sole owner at that time, who was responsible, but may not have any ownership now.
Well, what I would say is that what you need to make sure is that when you buy a practice, that you address a liability for anything that comes up in the future, for instance. But you also have to make sure they have the funds to pay for that, right? And you would also describe at the time that comes up with you that was pre-me, and be able to document that. So you need to address that in your transfer of ownership sale documents. That's clearly a situation where you're buying a practice. You need to have a lawyer involved, not to be self-serving. But obviously, that's the situation. And make sure you have the appropriate language that divorces you from the responsibility for claims that pre-exist to you. Yes, right. The asset sale agreement, right? Which there are probably different levels of quality of those agreements, but you want to make sure that language is in there. That's kind of a basic thing that ought to be included, and that goes for malpractice, all kinds of things, right?
Okay, we've got time for one
Statute of
more.
limitations.
6.
One last question.
Yeah.
My question is I go to the attorney, the counsel, and ask his opinion on the issue. Because some of the things are very much now, and he gives an opinion on that, and I act on this. Why should we?
You're saying counsel? Yeah, you talk to a lawyer, and he says you can do this, and you have that in writing. Yeah. I mean, what a mitigating factor can be that you relied on the advice of outside counsel. That is a defense that's commonly used. I mean, just him telling you though is probably not going to be good enough. You want to have it in writing, and it won't necessarily eradicate your liability, but it may lessen it. See what I'm saying? It will likely mitigate. It depends on the facts and circumstances completely. However, you can generally state that it will mitigate it. It will be something that will be considered by the U.S. attorney, for instance. Absolutely, they will consider it. To what extent they take it and reduce your liability or eradicate it altogether is an individual circumstance. But it certainly will help you, generally speaking.